Mr. Speaker.
Dr. Kennedy Graham.
Thank you, sir. The Green Party opposes the Intelligence and Security Bill. We respect the intention of the government, and especially the Attorney-General, the Honourable Chris Finlayson, and also the reviewers whose report underpinned the legislation. We acknowledge, though not without critical scrutiny, the changing global context in which the report and the legislation are conceived. The issue, Mr. Speaker, is this: what mix of constitutional principles is optimal for our nation at any one time? And in that respect, my party takes a different position from the government. The stated purpose of the bill is, quote, to protect New Zealand as a free, open and democratic society. It is to achieve that by establishing intelligence and security agencies that contribute to our national security, international relations and economic well-being, with adequate functions, powers and duties. Those functions, sir, are to be performed in accordance with domestic law and human rights obligations, subject to institutional oversight and appropriate safeguards. The bill fundamentally restructures New Zealand's legislation pertaining to intelligence and security. Throughout its history, New Zealand has had separate legislation covering these issues, and for good reason. 4 pieces of legislation, in fact: the SIS Act of '69, the Committee Act of '96, the Inspector General Act of '96 and the GCSB Act of '03. The bill sweeps all of this separate legislation into the one single act. It is not going too far to say that, given the basic nature of the values and principles involved, this is primary legislation with constitutional implications. This sweeping restructure, we are told, is for 2 reasons. First, a heightened threat level. The past half-century has seen a growing sophistication of security threat. Second, efficiency. There is a consequent increased need for the SIS and GCSB to work together and pool their resources and pool their expertise, and they are hampered in this respect by separate legislation. So on that basis, the bill proceeds to fundamentally amend primary legislation by virtually blending 2 agencies under a single authorisation framework and providing for joint warrants. We shall probably have occasion in committee to explore the intricacies of the 150 pages of the bill. If it goes into committee, we shall be interested to learn what New Zealanders think of it. Meanwhile, this first reading is the occasion to reflect on the fundamental principles behind the bill that argue for or against its passage. Let me offer a few comments. The bill is the direct child of the Cullen-Reddy Review, the first independent review of intelligence and security in the country's history, called for in the 2013 amendment. The report is a substantive and thoughtful document, a considerable portion with which we disagree. The report is headed "Intelligence in a Free Society," thereby advancing the presumption that intrusive powers and civic freedoms are compatible. It opens by advancing what it calls 2 extreme views of the place of intelligence and security in society. One extreme is that state and individual security overrides other considerations. The other is that freedom and liberty are so precious that any secret activity by state agencies inevitably threatens those human rights. Most people's views, the report says, lie between these 2 extremes, as do those of the reviewers. Voila! The review has just attained unction, having mortgaged the centre ground by assertion. The review recommends, and the bill states, that its fundamental purpose is the protection of New Zealand as, quote, a free, open and democratic society. This becomes what is called the guiding principle by which the activities of the agencies must be judged. Yet in paragraph 12, the review asserts that the agency's activities are, by their nature, intrusive. Mr. Speaker, intelligence gathering on a citizen that is in any way and to whatever extent intrusive, by definition encroaches into the human rights of that citizen. How can we gather covert intelligence about a citizen without intruding into that citizen's right to personal privacy? We may claim justification, but we cannot claim we're protecting a free society and in the next breath acknowledge that the action is intrusive. It is too cute. To the extent intrusion exists, that is the extent of encroachment on freedom. That is not an extreme view, it is a palpable truth. In Chapter 1, the review says that, quote, "We have approached this question from the perspective that security and privacy are complementary rather than competing rights." In support of this, it cites the Universal Declaration of Human Rights, Article 3, pertaining to life, liberty, and security of the person. It does not cite the UN Declaration on the Rights of Indigenous Peoples, which reaffirms that Indigenous peoples, in the exercise of their rights, should be free from discrimination of any kind, something for which our state security apparatus has not displayed a huge amount of respect in the past. The review asserts that, quote, "most rights are not absolute," and it cites the Bill of Rights Act, which provides that rights may be subject to reasonable limits that can be demonstrably justified in a free and democratic society. It does not cite the Civil and Political Rights Covenant, which identifies certain non-derogable rights. Setting aside for the moment whether intelligence gathering breaches those rights, it is not proven in the review or the bill why the expansion of intrusive powers is justified. It is simply asserted that times have changed and the threat has increased. Yet the official level of threat assessment for New Zealand remains low, revised up from extremely low in October 14. A low threat level is defined as possible but unlikely. Neither the review nor the bill explore this in detail, yet the bill rests its justification for centralised and expanded intrusive state powers on this basis. That is, in the least, contestable. The New Zealand assessment differs from those in the US, UK, France, Belgium and Australia. The vulnerability of a country to global terrorism is broadly correlated with the extent of its military engagement with terrorist groups. The Green Party has maintained that terrorism should be regarded and managed as a criminal issue, both domestically and internationally, not treated as a threat to international peace and security. The only exception to this might be Islamic State, which possesses territory, claims universal jurisdiction and declares war against UN member states. That is debatable. But most terrorism around the world is domestic in nature and focus and should not be hyped as an integral part of a global security threat. The review recommends that the Attorney General be the responsible minister to approve Tier 1 and Tier 2 authorisations for intrusive powers. As the principal officer of the Crown, the Attorney General is the appropriate member of the executive branch to take into account human rights implications and ensure the rule of law is upheld. This raises the issue of the relationship between terrorism and the use of force by the state, including a foreign state, between warrants for intelligence gathering based on suspicion of terrorist activity on the one hand, and for criminal liability on the other hand, based on suspicion of breaches of the law of genocide, war crimes, or crimes against humanity. It is one thing to authorise a warrant to intrude into the private behaviour of a New Zealand resident. It is another to issue a warrant for the arrest of a visiting foreign leader for the excessive use of force, as occurred in 2006 in this country, when the then Attorney General saw fit to quash a magistrate's arrest warrant against a foreign leader within 24 hours of its authorisation. The rule of law, Mr. Speaker, works both ways if a free, open and democratic society is to retain its integrity. The problem with this bill is that it authorises the centralisation and extension of state intrusive power into the private lives of individuals after a spate of inquiries have shown the loose regard for law that those relevant agencies have maintained. Sir, there are many nuances to this all-important bill, and no doubt we shall explore them in committee. Suffice to record here in this first reading that the Green Party sees no sufficient case, as laid out in the independent review, to justify the centralisation and expansion of intrusive state powers incorporated in the bill. We shall therefore be voting against it.
Dennis O'Rourke.